Welcome back. John Campion is chair of the Civil Litigation Department of Fasken Campbell Godfrey. He's also board counsel for the Ontario Energy Board and the Ontario Automobile Insurance Board. He's taught at the University of Toronto Law School and at Osgoode Hall Law School as the author of numerous articles and case books. I met John a few years, well, I guess I've met him a lot longer than that, but I met John in a litigation context a few years ago when we were respectively counsel for the Martin and Chrétien leadership campaigns, and we're having almost daily, but at least weekly, arbitrations together. John is going to be speaking about the strategic overview of litigation in the employment law context specifically. I'll be following up with some of the practical and unfortunately more mundane considerations that we have to encounter in conducting employment law cases. But I think it'll be a nice interface.
Ladies and gentlemen, would you please turn in your materials, if you don't mind, please, to B23. And just keeping your finger on those pages, going backwards and forwards, there is a fact situation, which is part at the first of Chapter B, which I will come back to after I have completed an overview. There is a notice of motion and a statement of claim which follows the fact situation, which has some resonance to a case which I had, but is all the facts have been largely changed. Certainly the names have. And what I propose to do is, starting with page B25, I'm going to give you a litigation overview. I make the distinction, as I'm sure many of you do, between a litigation solicitor and a barrister. And much of the work in this field is really done as litigation solicitors. Most cases settle. The litigation barrister, and actually taking these through to trial, I suspect, like most cases, it very seldom happens. And it's in part because, of course, you've got individuals usually at the wrong end of one part of the case, and they just simply can't afford to go forward. So what I'm going to do is I'm going to give you a barrister's perspective as opposed to a litigation solicitor's perspective on what I look for when I get involved in a case like this. And there are two fundamental ideas that I'd like to run through as a theme. And I'm going to be using, and starting at page B25, and needless to say, it's meant to be used as an aid to scribble on that, as opposed to possibly your notes, if anything I have to say is worthy of being written down. The first notion is this, is that everyone deserves a day in court, but most cases don't deserve a trial. And the day in court can be very salutary, and the threat of a day in court is one of the most valuable settlement tools I'm aware of. I'll come back to that theme in a moment. The second one is this, is that whenever the merits are being reviewed because there has been an injunction brought or because of a need for a particular order, such as an Anton Pillar order looking for documents, the merits have to be reviewed. And once the merits are being reviewed, you should consider, in a field like this, a motion for summary judgment. For this reason, you have all the facts there in any event. And while you may not get a full judgment, Rule 20 allows you to get a partial judgment. You can get it by declaration, for instance, of the length of time for notice. So you can get a declaration that indeed a contract of employment existed. You can have all of those issues determined even though there remains a one-day trial about cause where you have two witnesses. The affidavits and the cross-examinations can be used for the discoveries, and you can get a speedy order for trial. So even though you will not ultimately, arguably, in many cases, be successful in all aspects of an employment matter where there has been an injunction brought or where you see your way clear to bringing a motion for summary judgment, you do get a comprehensive view very early on. Most cases don't deserve a full trial on most of the issues. They're simply things that ought to have been settled in advance. And where you do have a single issue, you should isolate it and go forward on a small trial. And I put it as high as this. I believe it's your obligation and my obligation to get matters, in particular in the employment field where individuals are involved, and I call that consumer litigation, where you've got people who need to have funding and they don't need to have many months of litigation and they can't afford it. How many times have you spent months or years on a piece of litigation and you've raised all kinds of fancy issues only to find that, one, you don't get paid, and two, the people are wholly dissatisfied if they do pay you, and three, the settlement reached has been so destructive that their respect for the process has completely fallen away, or four, on the eve of the, because everybody's totally exhausted, everybody settles. None of that should happen, and we are going to suffer because it's going to be taken out of our hands, in my view, as lawyers, unless we find ways to deal with these matters quickly. So the second point then is wherever merits are being reviewed by a court, you should consider a motion for summary judgment. That is your day in court. It will not necessarily be a trial. Now, with that in mind, those two parts, let me then deal with, if I can, at page B25. And what this is this is an analysis that is somewhat, is my own view of litigation. When I went through the bar admissions course, or when I went through law school, or when I first went to Faskin's, in that department that was filled with an extraordinary array of characters, Williston, Sapinka, Rolls, John Laskin, Julian Porter, David Roebuck. There's just a whole host of characters who were all sitting on 1/3 of one floor, all jammed in. Tour, Kelly, just a fabulous array of barristers, and they basically had a certain view of litigation, and this is in part theirs and in part my own. And there are only three things to think about when you think about litigation. They are analysis, process, and strategy, and I've listed them on that page. The analytical side is what's the legal framework? And the question to be asked and answered, which is, I'm sure you do it every day, and indeed we've heard one talk upon it already, but it does bear repeating. Because when I first heard it, I was 3 or 4 years out, and it made so much sense because it sort of crystallized what we were up to, and that is, what's the cause of action? What are the components of the cause of action? And what flows from it? That's the legal framework. And you should do that for every cause of action, regardless of whether you have 1 or 10 in a pleading. And if you do that, and you do it severely, and I know that the good litigation barristers do it this way, then you will find that a lot of peripheral things either become relevant that you didn't think were relevant, or if they are irrelevant, it's shown to be so. So the whole legal framework is a critical starting point because it affects who are going to be parties. It affects the nature of your pleadings because you have to plead material facts, and the difference between evidence and material facts will change depending on your causes of action. You have to understand when it comes to discovery, what the limits of the discovery are, because the evidence and the material facts which flow from the legal framework all of a sudden become relevant. And one little practical hint that I'm sure you're all aware of, but it has always helped me, I learn more from clients walking out the door saying, and there's one more thing, I don't think it's relevant, but what do you think of this? And how often it isn't a new cause of action for breach of fiduciary duty, or something like that. And I'm sorry if I'm talking to maybe a more junior level than this crowd, because I recognize that some of you might even be older than me. And so I hope you'll all apologize if I'm speaking at too low a level, but I think it's important to put that in context. I'll leave that, because that's a whole topic for another day and another time. The next part is process. And this is important for employment law, in my view, because it's perfectly obvious to me that courts are great places to set up the issues because they happen quickly, you've got time limits, you can get the whole thing going. But how often is it perfectly obvious to everybody that this ought to be mediated or arbitrated privately, quickly, by somebody, anybody, in order to come to a conclusion? Because people can't afford us, and we never get paid anyway for what we do in these fancy areas. So knowing that to be so, it's in our financial interests to get these things quickly to an end. And it is, more importantly, in our public interest, and I believe our public duty too. So if you can't bring, through the process in a court application, a motion for summary judgment, you should immediately consider, I wouldn't consider the private court, particularly in this field, but certainly mediation or arbitration is very significant. And of course, I'm sure you've all been to any number of seminars on mediation as of late. But, and there are fancy other parts, that's mediation arbitration, where you have a mediation which if it is not successful, immediately flows into a binding arbitration or some other such thing. Or there's another way that they deal with it, although this is less likely in the employment field, where you have a mediation at a lower level, and you get the senior executive officers of a company to commit 2 days or 1 day, where they will sit with the mediator and try and settle the matter, even though the vice presidents or whatever they are haven't been successful. And if you commit a chief executive officer to a day to settle a matter, 99.9% of the time he will do a deal, because those kinds of people, or she will do a deal. Those kinds of people, executive level people, are used to doing that, and they know the costs and the burden of litigation, and they are interested in litigation. So the hybrid ways of dealing with these things, which again I don't have time to go into in detail, are important. Analysis and strategy and all the components of these things, and I think this covers the waterfront in terms of a process, but there's a million variations. There's something like 32 different kinds of mediation arbitration models. Each one of those, analysis and process, affect strategic choices, and it's really strategic choices that I'd like to focus my attention on, with the theme that everyone deserves a day in court but not necessarily a trial, and with the theme that whenever merits are being reviewed, you should consider a motion for summary judgment. Let me give you an example on the latter point. If I'm facing a motion for an injunction with a non-competition clause, or a motion for an Anton Pillar order, or some such other motion like that, the merits are going to be discussed. I stand alone as a defendant, meeting accusation upon accusation of breach of trust and all those other kinds of things. If I'm very confident in my facts that those are excessive, and I bring a motion for summary judgment, the risk at the motion that I'm going to be successful most often stimulates a settlement in this kind of field. If I didn't have that lever, then I'm less likely to get to it. And they say, oh, you can't be successful because it's an issue of cause and it's an issue of credibility, and therefore. I then remind them of Rule 20.05, which allows me to get some aspect and a speedy trial, and all of a sudden the landscape has changed. Instead of this being a 5-year program of litigation where a company wants to fight off an employee that they're particularly upset about, all of a sudden they're facing a chance, which companies seldom take, that they might get blown out on one motion. And that lever or that answer back is what I always look for when I'm responding to a motion. It is critically important from my strategic notion, and this is based on my sort of human endeavor, to do that in reverse so that I'm not sitting there alone. Now, you've got to be careful, because if you go too far, you're going to get hammered in costs, and you want to be able to get something out of this kind of motion. But I have no doubts in my mind that those strategic considerations are important. They are important for other reasons, and when I get to the page on strategy, I'll explain it to you. If you could turn with me then to the next page, B27. You will see there that I list sources of law. Now, this was meant for a broader audience, in this case, our major source is common law and statutory. It's seldom that we'll get into constitutional issues, although it's possible. We obviously will get into the Courts of Justice Act, and this is meant to explain to people that the Courts of Justice Act has substantive components to it where you look to a source for legal framework or for a cause of action. The most important of which being is the right to a declaration. The right to declaration is not a common law or an equitable principle. It is a statutory right. And it arose, obviously, in the early days, got translated into the old Judicature Act and retranslated into the Courts of Justice Act. And one other important point, which I'm sure you remember from law school, but I'll remind you, is that it also deals with common law and equity. Brought the courts together in 1896 here in Ontario, 1860 in England, all of which came out of Charles Dickens' Bleak House. You know, wave upon wave of the fog, and generation upon generation of people, and everybody has died on that estate case. The only people left are the lawyers. They continue to be arguing at court. Well, that was how Bleak House began, and that led to the reform of the courts. There was reform in the air in the 1830s, but this was a particularly important point. But the thing to remember is this. You have to distinguish when you're dealing with common law and equitable remedies, because you have different kinds of defenses for equitable remedies. You've got all the clean hands type answers to an equitable case. And it's not always clear what is an equitable right and what is a common law right. You have to search something that look like equitable remedies indeed are not. So you should have a good awareness of the difference between the two. But wherever there is a conflict between a common law right and an equitable right, equity wins. And that's enshrined in the Courts of Justice Act, and that's a somewhat eclectic point, but you will be possibly dealing with fiduciary obligations, which is probably an equitable right, although you should always check to be sure, and as opposed to a common law right. The major, and obviously evidentiary principles come from common law and so forth, but for our concerns and your concerns in the employment law field, it is important to note that really what you're dealing with is a contractual right, common law right, an implied term for notice when people have been dismissed. Now, there are lots of other issues in your field, obviously, but the important point, I think, in terms of wrongful dismissal, if that's the focus of this, is that it's an implied contractual term. It's a common law right that you're asserting, and that leaves you with a battery of defenses, but not any equitable defenses. You do have equitable defenses if you're pleading other issues, either in tort if they arose from equity. So that's a very short description of sources of law. But and over the page at B29, I set out common law, and I've just circled numbers 1 and 2, contract and tort, because those are the causes of action most likely to occur in this field. And I won't bother detailing them in any long-winded way. You must be very careful with the difference between causes of action and damage. I'm sure you know that, but it is a tricky business at times, because people often think that mental damages for some form of mental disturbance or mental problems are a cause of action in and of themselves. Well, they aren't. At least I don't think they are. They are damages which flow from some other cause of action, some other tort. And you just simply have to be careful. And this is why you have to go back and you say to yourself, what is the cause of action? And is this a damage claim, or is this an actual substantive legal framework? And it will change your perspective on how you plead it and how you go forward, depending on the answer to that question. Moving on to page B31, nature of relief. Obviously, damages are most common in your world, or in our world. Injunctions arise from time to time. Mandatory orders for reinstatement, either final or interlocutory. On 2 occasions, I have been successful in getting a mandatory order for reinstatement in an employment contract. The first one was against Havergal College, and that was largely because a very popular teacher was dismissed 2/3 of the way through a term, and I was going to subpoena every single member of the class, which was 30 girls, all of whom wanted to come. And the prospect of that coming to a defense of a teacher was so awesome for the school that they reinstated her. It had nothing to do with the law. But the idea, and indeed I had the subpoenas already and we were just ready to go. It was going to be somewhat chaotic because it was going to be the first day of the last term when they're all writing their OAC exams. And you can imagine that didn't seem an attractive alternative because, of course, all the press would be there. This teacher was a real character and a half. And a bit like, what's that movie? Yes, Dead Poets Society, a bit like that kind of passion. And anyway, the end result is that we got reinstatement. Now, that was threat of litigation with the idea of subpoena or actual litigation because we claimed it. The next one was this, where people were partners in a business, and one held 51% of the shares and the other one held 49%. And through a very complicated series of personal and other issues, the 49% person got fired. And we moved for reinstatement on the grounds that there was a partnership and an underlying term of that partnership, which was implied as opposed to express, because it was not in writing, that as long as he was a shareholder, he would have a right to employment. And so we moved for a mandatory order for reinstatement. We got it. Upon reinstatement, he was delivered his back pay, which was over that 3-month period $1.1 million, which helped fund a little bit of the litigation. And we also got an injunctive order, which I had our corporate people draft, which controlled every aspect of this company. Every single aspect of this company. They couldn't do anything without my person's consent. It also ordered them to give up a whole host of information. Now, what that did, of course, was that the person who had fired, he was the president and CEO, he'd always been in the ascendant in his personality and his style. And he was never going to settle this case. This was a personal vendetta. When he all of a sudden faced the idea that his company, for even expenditures, and this was a big multi-million-dollar worldwide company, was going to be faced with an injunction before he could make a single step sideways. He had needed the consent of my client, and the man was going to be back on the premises. His arrogance and his passion to win all of a sudden diminished a lot. Not completely, though. And it's interesting, here's what he did, and this is a strategic notion which is in the eclectic side. He refused to give up information when my man walked into the office the first day. Instead of coming back to me and me writing the lawyer on the other side saying, your person's refused to give up the information which has been ordered by the court, I just brought a motion for contempt. The judge who'd heard the motion for the injunction in the first place had then gone down to St. Thomas. So I made an appointment the next day to go down to St. Thomas. I served the motion at 4 o'clock in the afternoon with the motion returnable at 10 o'clock in the morning. And the person that I served with the motion for contempt, there were 3 of them. One was from England. He was sitting on the first class section of a BA jet going to go home when he got served, and the motion was to put him in jail. It's astonishing how effective it was. We never had to appear in St. Thomas, but the strategic notion of going to jail for failure to live up to this order, rather than me writing a little note, and the other people on the other side said, why didn't you just write me a note, give me the courtesy? The reason I didn't is that this person had not learned his lesson, that he was no longer in control of anything in that company. And he would have continued to hound my client and be disruptive, but this reminded him. And in the end, we had, and there's one other trick I'll tell you. We did get this injunction. But what I did is I got 3 dates. I got one date, a second date 7 days on, and a second date 60 days on. I therefore, on the first day, asked for a 7-day injunction, just a partial one. The next time, I asked for a 60-day injunction, but I had them put in the order that the injunction was to last until the next day was fixed, sometime in July, or the date that the motion can be properly brought on. Now that meant if we went past July, the injunction continued. They agreed to that on the other side, and of course they started filing materials. We had voluminous materials like this. They filed the same amount. We were still cross-examining in December. We'd been to England cross-examining, we'd been everywhere, and we still had this injunction. Well, guess what? The company was sterilized, we settled. And instead of the $2 million that they offered him, they ended up giving him $14 million. And we were out of there. But it was all strategy. It was all strategic concerns, oftentimes at the little tiny weeny level of things like how long was the order going to last, and having those 3 dates, because it's easier to get an injunction for 30 days than it is to have an indefinite until trial. But with that little add-on, I mean, it was expressly discussed. Whether the other side captured the significance of it or not, I never did understand. But it was very, very, very effective. So mandatory orders can be very helpful, reinstatement from time to time. Declaration is very important, and I have shown you where it comes from, and I'll carry on now. If you turn to the next page, B33, it's amazing. You're going to give me a hand as to when I've got some time left? Okay. This page sets out a truth, which is obvious to all of you, but you may not think of it this way. And the truth is this. The entire litigation process is meant for this one thing, to stand up with a body of fact and some case law before a judge and argue your case. Everything else is subsidiary to that. And if that's what you have in mind, you can see how a motion for summary judgment begins to seem a whole lot more logical. If all the facts are there and you've got the law, why wait? And so when you see here in this page, final argument on law and evidence, it doesn't matter whether it's an application, it doesn't matter whether it's an action, and it doesn't matter whether it's a motion. However you get there, that is the key to all litigation. That's all you're aiming for, folks. And that's why I say a day in court can is just as good as a full trial. And you can get there by different means. So once you have that straight, everything else begins to revolve around those kinds of issues. Now, pleadings, discovery, pretrial procedures, including offers to settle, and trial, mitigation, and experts for being used to determine how easy or hard it was to get a job. Mr. Levitt deals with all of those matters in his paper and will deal with them. But they do arise on this page. And I'll leave him to deal with some of the finer points in your field which may be more immediately appealing and practical to you. Now, I've dealt with motion for summary judgment in lieu of the trial, and that's really the significant thing to draw from this page. And it will begin to affect, if you start out with what's the cause of action, and you look here, you'll see preliminary matters, who are parties, limitation periods. It will depend upon who are parties, what's the cause of action. It will depend upon pleadings. As soon as you ask the question, your pleadings are immediately affected. What I do in a field which I'm not familiar with, is most of the fields I litigate in, I'm not, because I'm of the view that the general litigator still remains a viable animal, contrary, I think, to the general trend. And I find that when I read in an area, that there are certain facts which are appealing, even though you may not even know them, but there are certain individual facts which are appealing when you read through a body of cases in the particular area that you're litigating at that moment. And it's those peculiar facts which give rise to questions which lead you to very persuasive facts which you wouldn't have thought of just by asking yourself, generally speaking, what's the cause of action? And that little trick is something I always do. I get all the cases in the field, narrow them down to my type, and then read them to look for these curious facts so that I know what to plead or not, or know what to ask on discovery or not, if they have previously been persuasive. That then deals with what I would like to accomplish on that page. And processes 2, 3, 4, and 5, I've touched upon and obviously don't have time to go into any detail. I'd like you to look, though, at page 6, if you don't mind. I've got 5 minutes left. A fundamental problem arises every time you get into a case where you know that the company, or indeed the individual, may have acted criminally, or may, of the company's case, or the individual may have fudged their tax issues, and you know about it as an employee, or where in some organization there's a professional complaint to be had. And the question is, particularly in the employment field, do you use those kinds of weapons? Well, I say you use them, but you don't threaten to use them. And I'm sure you know the reasons why. If you're going to do it, do it. But recognize that a person in jail is very difficult to get damages from. And so you have to consider, and then of course there's whether there are lawyers or not, and that's another issue which you have to consider. But if you're going to do something, such as what I did, I subpoenaed the evidence which dealt with a tax issue in a case, and I got the accountant, I got the chief executive officer, and I got the outside accountant and some individuals who were advisors to this company on what was a tax fraud in an employment case. They had brought an injunction, which is the fact situation which I have in front of you. We countered by serving subpoenas on all these people, knowing that they had been involved in this tax issue, and it's surprising how quickly we settled. And it wasn't a threat, so it's perfectly proper. It was relevant to the credibility of the people who were suing us for an injunction, and on that ground alone, it brought pressure to bear on a very significant issue. I don't recommend you do it without really thinking hard about the ethical situation and the effectiveness of it, because it can also cause a response which is fierce and you'll never get a settlement. So it really depends upon their rights and wrongs of it. That then finishes the bits and pieces. But at B45, I have the process choices in an action. You'll see summary judgment, stay of proceedings, jury, non-jury, injunctions, and Anton Pillar. Each one of those affects your area sooner or later. And all of them, whenever they are raised, should trigger in your mind, if something like that happens, a Rule 20.04 and Rule 20.05, motions for summary judgment. I've dealt with that. I've dealt with the possibilities. Mr. Levitt deals with motions for summary judgment in part, and the restrictions in this field where there's mitigation. And that's an important point. If you've got mitigation, but the way to handle that is to get a declaration about the notice, which finishes off the case, subject to, therefore, a determination of mitigation in some trial or reference, as the case may be. And if that's all that's left, then you can get a declaration and still do an end run on the fact that you can't get a motion for summary judgment where there's a mitigation issue still running on an employment field. The rest of them, jury, non-jury, Mr. Levitt deals with, and stay of proceedings. Now, that leads me to the strategic implications. Now, I have dealt with them as I've gone through these notes, and the best way, I think, to do it is to look at backwards in time, if you don't mind, to the fact scenario, which I obviously don't have time to review in any broad detail, but I would like to just simply note that within this fact situation, We had a motion for an injunction. I immediately served my statement of, because they were suing the employee for an injunction. We immediately started the action for wrongful dismissal rather than just fighting the injunction along, so that they would be compelled to file their defense so that I could then get a motion for summary judgment, because you can't bring it until the pleadings are closed. And in this case, they'd only started it in anticipation of litigation. A couple of important points. We made an agreement with the injunction which was off the record. I did not admit to an interim order pending a full hearing and us filing materials, because I hate to argue as a barrister from the perspective of an order existing. I find it very difficult. So do a private agreement only to be used in the court if there's a breach of it or an alleged breach of it. So you can still protect somebody who says, well, I don't want something like that because I can't enforce it. You say, yes, you can. We'll have a private agreement that you can raise it before the court. That then keeps all these issues which were outstanding away. The second thing was that this company was worldwide. There was only a few people in the field, and the CEO of the company, Ms. Brown, as she is called, went around the world to all the people that could have been potential employers saying bad things about my client. We could have sued and libel. I decided not to, because I was looking for a motion for summary judgment, and you're not going to get easily a motion for summary judgment and libel, plus the complexity. Too costly. If we had a libel case, it was a good libel case, but it was just too much money. We had a clear focus on what we wanted. We wanted a settlement, we wanted them to stop, and we wanted to get on with our life. So I didn't sue, but I did claim punitive damages for the statements having been made. Not on the basis of libel, but on the basis of affecting, in effect, the breach of contract. So that was by giving insufficient notice. And that was a strategic decision based on the pocketbook of my client and the complexity of a case and a desire to bring pressure to bear as quickly as I could. There are other strategic considerations that go through these fact situations, but I think I've touched upon some of them in the main discussion. There are the notice of motion that dealt with the injunction and the statement of claim which was filed, which is hopefully asked and answered. This was an interesting case in the statement of claim because there was so much irrelevant you could have put in, and we had to leave a lot out. And so you can see that it's a bare bones claim. And that came from saying, what's the cause of action, what are the major issues, and paring them down. So ladies and gentlemen, I'm sorry it was so quick, and I hope it was at a level that wasn't too basic for you. But my goal was to give you a strategic sense from a barrister's perspective, and the kinds of tools that you might use, or I'm sure all of you do use, or some of you use from time to time. And I take it we may have some questions if we have the time, and thank you for your attention.
Thank you, John. Those of us who do work for plaintiffs in wrongful dismissal cases invariably are confronted with the real issue of how to bring quick pressure to bear on the defendant in order to expedite a settlement at the time that the plaintiff obviously most needs the money. And John's been very helpful in giving us some ideas. The only case for summary judgment on wrongful dismissal in a classic wrongful dismissal is, as John alluded to, the court found that since mitigation was still an issue at the early stage, they wouldn't deal with it as a matter for summary judgment. The problem is, of course, if you bring a motion for summary judgment and fail, the prima facie rule is there's solicitor-client costs against you. Now, with the expression in Mactinger and Mr. Justice Cory's comment today about the importance of employment and the importance to the individual on a psychological and sociological level of the severance of employment, the courts might be more receptive to early applications for some sort of interim relief in addition to the mere employment standards relief. And another thing you might do, you could wait, of course, for the period of notice to expire. That doesn't really help. You could file early mitigation evidence and get into some of the BC cases where they have their summary trial proceedings so that it gets to court prior to the expiry of any potential notice period, and the courts have various ways of dealing with that, and perhaps that's the kind of remedies that we should be seeking. They might ask for an accounting, they might simply make orders regardless of what the ultimate outcome is of the mitigation effort, or they may give essentially order a bridging formula or a continuance of salary subject to mitigation formula as part of the court order. But there's only been one case to date, and certainly a lot of the suggestions made by John have certainly made me think about the prospects of looking at that and looking at that more commonly in wrongful dismissal cases, especially if there's some aspect of the fact situation that's particularly compelling. I had one case, I mean, even now, we've got to look more commonly at that sort of interim relief in the exceptional case, as well as obviously the more garden variety wrongful dismissal case. I had one case where a client's manager of human resources had set up her husband as a placement agent, obviously under an alias, and had put about $1.2 million of work through the company in placement fees over the last 3 years through this fictitious placement agency, most of the work being done by her herself. And of course, no one had ever met the husband, so didn't realize the fraud. We brought an immediate, well, we went to court. We found out about this on a Sunday morning. We went to Mr. Justice Rosenberg's home and got an immediate order requiring him not to leave the province and restraining any disposition of any of his assets. The problem is either he didn't abide by the order or had already left the province. We weren't able to find him. We had the order in place and started sending it around to whatever banks we could find. And like we sent, I think, to every single major bank and trust company in the province, just in case he had assets there under his name, his alias, and the name of his companies. And in the Turks and Caicos, where he knew he had some assets. We then we issued a statement of claim, got a default judgment. He then surfaced, setting aside the default judgment, and the court made an order in setting aside the default judgment that it would set it aside on the basis that he had torn to the jurisdiction of Ontario, attended a solicitor's office so he could serve with a motion for contempt of the first order, and that he put $250,000 into court against our, what at that point was a $1.2 million default judgment, and paid $20,000 in solicitor and client costs. Well, needless to say, he did not. And we got our default judgment, and we found some of his assets and are fighting it out in various jurisdictions in British Columbia and the Turks and Caicos right now. And his wife, we made a very quick deal with. She gave a full accounting of all of her assets, which came to around $280,000, and we agreed to take $240,000 of them and give her a full release, including certain properties. But those are, of course, not the garden variety cases we get in this area of the law, although we certainly can be a lot more creative in dealing with the garden variety cases as well. And I found John's talk quite illuminating with respect to giving me some notions with respect to how to deal with that. I'm sure we all did. My talk is going to be on some of the more mundane aspects that we deal with in a garden variety wrongful dismissal cases and how we advise clients. Now, what we generally do is focus, I think, too greatly on what's going to happen at trial. And that's certainly important because it crystallizes the party's appreciation of what the likely outcome is and therefore impacts on the ultimate settlement. But 99% plus of wrongful dismissal cases settle without trial, so I think we should emphasize to a greater extent what will influence favorable settlements, in addition to simply the ultimate outcome if it ever did go to trial. And in doing that, you have to put yourself in the minds of both parties and understand their psychology. What are the employees' motive? Well, obviously obtaining monies while still unemployed. Concern is the company's comparatively deep pocket. Concern for their own reputation. Desire to maintain a positive relationship. Uncertainty is the result. Concerns of the fact of the lawsuit itself will create difficulty for them in reemployment. A need for a positive reference. Fear that the employer will learn of some real or imagined skeletons in their closet. And these and others are the hidden persuaders in litigation. Obviously, if you could determine when acting for an employer what the employee is most fearful of and play upon those pressure points in obtaining a settlement, you're going to be more successful. And part of that is ascertaining the particular psychology dynamics of the individual who's on the other side of the litigation, the individual plaintiff. If they're concerned at relative finances and a need for continuing monies, obviously bringing motions are going to be successful in acting for the defendant. Refusal to give a reference, breaking off of social contacts will obviously motivate some for employees concerned about skeletons in their closet, arguments, and misconduct in the context of either the notice period or cause for discharge, because the doctrine of moderated damages is still potentially alive and well, according to the Court of Appeals decision in Queensberry in this province, are matters that you could consider. Now, you've obviously got to be cognizant of your role as a solicitor, both with respect to the rules of professional conduct and otherwise, and you don't make frivolous allegations. But if there's something there, those allegations can be successful as hidden persuaders. On the other hand, you've got to look at the corporate culture of your particular client and determine whether they want, in the broader scheme of things, to be making those allegations, and whether in a particular employee's case, those allegations are simply going to strengthen the resolve of a particular and differently constituted employee. Hidden persuaders for the employer include fear of creating a precedent, fear of damaging relations with customers and suppliers if that particular employee has those contacts, fear of damaging the morale of other employees and treating a particular former employee badly, the effect that litigation with a particular executive may have on the company's competitive position, adverse media publicity, and the cost of litigation, which is a factor, obviously, ultimately for both parties. If, for example, the fear is damaging relations with customers, the employee may start the case by obtaining letters of reference from a couple of customer contacts to show their good work. I mean, that's quite a reasonable approach. There's an inference for their former employer that more of such letters might follow. If the fear that the employer has is one of creating a precedent at a time that many employees have been dismissed or about to be laid off, the employer, obviously, from its standpoint, is best off not to settle quickly, except for some lesser amount that might be reasonable. If the fear is one of damaging morale of the remaining employees, the employer may want to be more generous, and the employee might be best off working very assiduously to maintain their liaisons with existing employees so the case becomes part of the regular office gossip. There's a real issue we always deal with respect to whether cause should be alleged when acting for employer. If there's no basis, you might, although I think with Vorvis and subsequent cases, it's more difficult now, there's a risk there's going to be mental distress damages or punitive damages as a result of such frivolous allegations of cause. There's certainly a risk of solicitor and client costs. It may be professionally improper. It may antagonize the court. And also, quite practically, what it may do is make relevant all aspects of your company's practices which impact on those allegations. For example, I've had many a case when I've acted for an employee where incompetence was pleaded. And there's a delicate balancing act you have to make. On the one hand, if you expand the scope of the pleadings too much, you may make the case uneconomic for a plaintiff, especially in a small case. On the other hand, if the employee can bear the discoveries, what you can do is respond to that by saying, well, A, denying, but saying in the alternative, if there is this incompetence or if there are any bad performance, it's as a result of the company's own mismanagement, and then start picking very carefully selected areas that do have some impact on the employee's performance, and that would result in your being able to obtain rafts of documents that the company would not want to be public and would not want to fall into your client's hands and the hands of other people that might be potential witnesses. I mean, that's another form of the hidden persuaders of litigation. And it's all relevant to the context of the proceeding which the company has made relevant. So the company has to think very hard, are they going to expose themselves to that? Because there's a lot of potential cans of worm that they don't want to open up, and the game may just not be worth the candle for them. And having made those allegations and beginning to ask in a very anticipatory letter, because you don't wait to simply serve a request for an affidavit of documents, what I will do in a case like that is I will write a letter to the company's representative and say, here are the documents that I want, and be very specific as well as very general, because you're not simply looking at the documents that come most quickly to mind. There might have been letters that they wrote in the scheme of things to their accountant or other or inter-office memos that were recorded that it may not even occur to them might relate to this case. But if you define the case broadly enough, especially with the very open scope of production that the courts are going to enforce in this province, you can define the parameters of your own production request well beyond what the company might quite legitimately have considered. And what about the era of computerization and memos to file and emails and that are generally recorded, even if you have to even if you have to set up the system software to get the old emails that have long ago been erased? Ask very specifically for that. Now, there's 2 points. One, if you get it, that's wonderful, and you've created a can of worms for your opponent. But if you don't get it, that might be even better, because then you can argue to the court, if the employee really did these things, these memos would have happened. Naturally, in the course of things, wouldn't you have anticipated that this employer would have written to their accountant about this problem or to this supplier about that problem? And the memos don't exist. Obviously, this is something that's just concocted after the fact. And that's quite a reasonable approach, as long as you can logically think through all of the ramifications and of every particular transaction. What would the reasonable person have done when confronted with that? I mean, isn't that how we win cases anyway? By pointing out those improbabilities in the litigation. But the point is, don't wait till trial. And that's generally the approach I advocate within my firm in any event. At trial, people are prepared. They've thought about the case, they've lived with it for a few years, they've spoken to their witnesses, they've thought through all of the implications, or at least a lot more of the implications. Do it in an early stage. That's why a well-planned examination for discovery is generally so productive, because they haven't thought through the implications. They're flying a little more by the seat of their pants, the particular opponents, and they say things because it makes sense to them at the time, but they haven't really thought it through, and they end up creating things that you can disprove at trial, or there aren't particularly consistent with the rest of their storyline because they haven't thought it through. In any event, you can use that battery of approaches in even relatively garden variety wrongful dismissal cases. Now, another advantage of pleading cause is that after termination, you find that employees are more forthcoming. The employee who's been dismissed isn't there anymore, and other employees are going to tell you things that they wouldn't tell you, and documents are going to surface that hadn't surfaced before the dismissal. And of course, very practically, faced with even a relatively slim possibility of losing a case, employees will generally accept a more reduced settlement rather than face the prospect of having to pay their own lawyer's fees, the defendant's lawyer's fees, and not recovering anything at the end of the time of unemployment when they have no money anyway. It's not just the employee, there's the employee's counsel to consider. The employee's counsel is less likely to operate on a quasi-contingent basis, waiting for the end to obtain their legal fees if they think there's a realistic prospect of failure. You should also consider whether to proceed with a counterclaim. Now, this is seldom done in Canada to date in terms of our jurisprudence. I mean, there's the Lister and Romford case that I referred to in my introductory remarks this morning. And few of us know about it, but it's a case that sets out a whole Pandora box of potential remedies for employers when employees have fallen below what their reasonable duty should be. And courts have said, well, when you think about it, the contract of employment, if it's breached, and cause, of course, means it's been breached, contracts are bilateral, not unilateral. So if a contract's been breached and damages flow from that, there is no reason at law why you should not be able to recover damages, and every reason why you should. And there have been a couple of cases in Ontario where damages have been awarded as a result of a dismissal for cause awarded to the employer. So those are matters that you should consider. Now again, juxtapose the advantages of that with the impact on your corporate culture of your particular client. It may, well, the game may not be worth a candle. It may be that your particular client will find such actions, and even pleading cause in some circumstances, to be antithetical because of the impact, again, on customers, suppliers, remaining employees, and because that simply isn't the way they do things. And obviously we have to, we're not only rebound, but as a realistic matter, respect that. Understand that all corporations are not constituted equally, and the approach has to change dramatically depending upon what client you're dealing with. You have to give them the whole parameter of potential advice, but understand what they're going to be comfortable with, and proceed not merely in forming your pleadings, but in the entire approach to the case based on what sits more comfortably with your client. Now, from the plaintiff's standpoint, the same issues. Right? Let me make another couple of points. Something like the Bohemian defense. Do you want to really plead your economic difficulties? It's a little bit like pleading cause. You're opening up again extensive examination of your corporate books and records, profits, previous profits, financial transactions. And I'm not sure that for the sake of a case that might be worth $15,000, a company is really best, well, it's in its interest to do that. Similarly, for the plaintiff, you have the same type of choice to make. I find generally I make the pleadings as narrow as possible when acting for a plaintiff, because I don't want to open up the door to either one, potential motions to challenge them, or two, a broad defense that can deal with a lot of issues. Even, for example, the issue of near cause. Assuming we're pretty confident there's no cause for discharge, do you really want to plead the employee faithfully, diligently, and competently performed their functions, which is put in so many standard form statements of claim? Aren't you then opening the door for at least a near cause defense, which might not be permitted, although the Queensberry case, it makes that more arguable now. But of course, there's been 3 Court of Appeal decisions say there is no such thing as near cause in Ontario, so that the door is very much open. The point is, you may want to keep your statement of claim as narrow as possible when acting for a plaintiff. On the other hand, there are other cases where it might be strategically important to open up the parameters, to bring in aspects of various hidden persuaders, such as John and I have talked about already. You might want to plead to open up doors that might be embarrassing for the defendant. And then again, do you plead punitive damages and damages for mental distress? The courts are increasingly saying, following Vorvis, that it has to be a separate tort, something separately actionable. But if you do, what's relevant to a mental distress claim? Isn't every single aspect of the employee's life relevant to a mental distress claim? Not merely things like confidential diaries, not merely things relating to their marital life and personal circumstances, but every vendetta and particular conflict they have at the time? I think it is. And you want to think very carefully, especially since mental distress and damages are usually $5,000, $6,000. Do you really want to open up the door? I've been told that I'm running out of time. So I'll just touch on a couple of other matters very briefly. We talk about summary judgments and agreed statements of fact, because I dealt with both of them in one recent case. It was the Campion decision to Cronk, which was Sear and Banting released the same day, and essentially with an asterisk, see Cronk for reasons. But what we did in that case, counsel for the plaintiff and I got together and decided the only real issue was one of notice. And the plaintiff put together an affidavit, which I essentially vetoed, and we put it together, we put it forward jointly as our submission as to facts, and brought a quick motion for determination of notice period. It was done at the outset. The whole thing was heard in an hour. Almost no legal fees. And it was very successful from both sides' standpoint, because from my standpoint, I thought we paid enough. From the plaintiff's standpoint, they thought they hadn't paid enough, so there was no real issue, and there was no in that case, there was no real purpose for the defendant in prolonging things. I see I'm out of time, so the other things I was going to comment on are touched upon in my paper, and I want to leave 5 or 6 minutes at least for questions. So thank you, and let's have some questions. Yes.
The oppression remedy has limited application in any case except where there's this partnership issue, and that's when, of course, it would be the most obvious one to begin with. Where you have people who have started a business together, even though it's in the guise of a corporation, and employment has ensued, and you have one of them dismissed because there's a difference of shareholdings, at that point in time, the oppression claim becomes relevant. I would have thought not for a normal employee-employer relationship. The notion of oppression would seem excessive and out of context in the case of a pure contractual claim with an implied term for notice, and probably more complex than you'd ever like to get. The advantage, of course, of where if you had it, of an oppression claim is that you can bring it by application and therefore add some very quick pressure on the other side to respond. Yes.
Aside from that colonial law, which I can't think of very many other areas of litigation which involve such high degree personalities, which of the various strategies that Mr. Campion and yourself and Candace do you think would be most effective in eliminating personalities and getting the parties to focus on the monetary issues? Summary judgment procedure, quick discoveries, examination of affidavits, which is an effective tool for getting personalities out of the way, getting people to focus on real issues, the money that's at stake?
I don't know if, other than obviously bringing pressure to bear immediately in some of the context that John was talking about, I don't know how to answer that question. I think it's not as much a matter of legal strategies as personal ones that really come into play. And some of us are better than others at containing that. I find that that's always an issue. Sometimes it's simply the elapse of time that makes people focus. But what I constantly tell people when they come to my office and they talk about things that ultimately aren't going to be relevant to the lawsuit is that, well, first of all, that, and precisely that. Secondly, that my job, from my standpoint, is to maximize their ultimate return after net of legal fees. And thirdly, that it's my experience that those issues will not be something that will be as consumed in the legal proceedings by them down the line as it is presently. I just keep trying to focus them on that, and it's very difficult. You're quite right. I don't have a magic formula or wand. I don't know how to deal with it, except to keep reminding them of that fact, and obviously to understand that extraneous issues build up legal fees in a way that doesn't ultimately help them. I give them things to read that help focus them on the legal issues as a matter of course when people come to the firm, and maybe some of us have better ideas than that. Maybe you do, John.
Two things might be of assistance. Firstly, where there has been a CEO and an employee and there's been a supercharged negative relationship that developed, it's oftentimes helpful to invite the CEO not to be part of the case at all or giving instructions. Have the Vice President Legal or the Vice President Finance or someone like that giving you instructions so that the personality of the CEO gets taken out of the picture if it's appropriate. It may not always be easy. And that sort of, on that side of the equation, helps the person taking instructions and trying to settle. And if you ever get to a point of mediation with the parties, don't have those two people in the same room if you can avoid it. Have this other softer, more gentle person. The second thing is to, particularly with an individual, if you ask for a $30,000 retainer, it's astonishing how quickly they come to settlement. And if you leave it and you just say it's going to cost a lot of money, they don't quite get the message.
It's a little bit like the termination itself. Generally, I find it's best to have the person's immediate supervisor conduct a dismissal, but if the person's immediate supervisor is the source of the friction between them, it's not a good idea. And if you can remove the parties as much as possible and and have them let you do the litigation, not them, which is precisely the problem I presume you're talking about. It's obviously that's what works. But Constance Olsheski would talk a little bit about some of those issues in her remarks. Yes, in the back.
You're bringing your summary judgment on quickly. Presumably you're bringing on quickly enough that's going to fall within the notice period. How do you deal with the damages?
The way in which I suggested is to have a declaration as to the notice, which is a contractual term. It's an implied term of the contract, so you can get a direct declaration as to its length, with a reference to determine what, if any, reduction will occur as a result of mitigation. And the reference can be back to the same trial judge, or can be to a master, although that's not a good idea these days.
See, there's a number of cases in British Columbia, because there's a summary trial provision, Rule 18A there, where that happens routinely, and there's a lot of case law in point as to what can be ordered, and sometimes they have ordered essentially bridging formulas.
The case, the chap at the pseudo.
Yes.
I'm intrigued by Mr. Campion's private injunction. My difficulty is imagining how you're going to get it. I would picture the situation developing in the courts in Florida, and I don't understand why a person would accept a private arrangement rather than going and getting the order, which put you at a much greater disadvantage than the private arrangement.
People seem to want, before they actually go and spend a day arguing an injunction, they seem to want to try and settle the thing. And in fact, they call up with an expectation of it. That is the moving party. And when I'm responding, I say, I will give you such an order on those very special terms, and I've never had a no. So indeed, I think the underlying principle is fairness. This has not been a determination on the merits. I shouldn't suffer, and if I am, or my client shouldn't suffer having agreed to it, you therefore have to be reasonable. It saves a lot of money, and there you are.
Front.
If a client comes to you after the notice period has passed, or which you feel is a reasonable notice period has passed, how are you restricted in your sort of strategy planning as to what you can do in terms of a motion for summary judgment?
I would have thought that once the, sorry, you go ahead. Howard.
Sorry, I'm just going to say it's easier because the mitigation is determined. You file an affidavit with all the mitigation documents. John?
Precisely. You've got no impediment at all, and you can get a final judgment.
Two more? Yes? One more? Last one?
In a situation in which the employer has given the employee a record of employment for purposes of unemployment insurance, et cetera, and put a statement like the employee dismissed for debt or the employee stole property or something like that, what use can you make of that type of a statement on that type of form where if the employee says it's not true, they in effect libel, slander me, what do you do with that?
Question is, what if there's a record of employment with a false declaration as to the reasons for dismissal? What can you, and it's theft or fraud?
Or disputable.
Or disputable. Well, the question is, what if it's libelous? What if it is clearly inaccurate? I think that was the point of your question. What can you do with that? Do you want to start?
Sure. Obviously a libel case, but you'd never really want to take it forward. Very few libel cases go to court and you end up with a jury and it's just too big a production. I think a punitive damage claim, though, is a very appropriate. If they have anticipated a disputed issue as to whether there has been theft or not, and it's in the litigation, and they put that on an employment form, and they're wrong, I believe that that would be good grounds for punitive damages on their breach of contract.
As well, there have been cases in which solicitor and client costs have been awarded specifically for that reason, And the last thing, the hint and persuader is, you'll see right on the form, and of course in the Unemployment Insurance Act itself, it is a statutory offense to make a false declaration on a record of employment. So if it is clearly false, of course they've committed a statutory offense, and you might want to plead that as well for whatever the various impacts that might flow from that. I think that's fine.
Yes. Ladies and gentlemen, Mr. Levitt, I'll take my leave. If you don't mind, I'm delighted to have been here. Thank you for inviting me.
The next speaker is Constance Olsheski, who, she'll be embarrassed to say, I met and have been friends with since 1972. And I won't tell you what stage she was in her career, but I'll say I was at second year undergrad at the time, and she was at Cineplex Odeon legal department, at which point I managed to persuade her to come to Howard, Levitt & Associates, where for the last 5-6 years she's been practicing employment law. She's also on the Weekly Chronicle show talking about the sorts of issues she's going to be talking about today.
Howard, I believe I'm already running into the next topic, so I would appreciate just being alerted by you as to when my time is up, because I know that we're way off schedule. Well, we at Howard, Levitt & Associates do exclusively employment law. There are 6 lawyers who work on an average, Howard, 18 hours a day, 6 days a week, and we encounter problems that possibly you have as well, and so I want to share some very basic street smarts with you. But clients who come into my office, first of all, say, I want my job back. They say, I'm being harassed, I want you to stop it. I want you to get me a good letter of reference. Then they say, I've had a terrible performance evaluation. It's wrong. I want it withdrawn from my personnel record. I'm being defamed by my employer. And when I first started, my initial response was, well, we can sue for wrongful termination, and you're entitled to 4 months. And they think that they may have walked into the wrong office, because obviously I can't help them. So over the years, what we have developed is a little bit of strategy to get responses to these issues for which there are no legal answers. Now, just to begin with, we'll start with harassment in the workplace. Now, you know that, of course, there's ample protection for sexual harassment, no problem. But there's more harassment in the workplace than there is sexual harassment. There's phenomenal harassment in the workplace, according to my clients. So how do you deal with it? I mean, of course, we know that there is the issue of constructive dismissal. And if it becomes so unreasonable that no human being can tolerate it, okay, you've got a lawsuit. But as Howard mentioned earlier, the law of constructive dismissal is in such a state of flux, and it's waning in its strength, that it's not something that you would jump to as immediate resolution. So this is what I tell my clients, or we tell our clients. First of all, the employee is to create a job diary. Start immediately. Write down everything, because credibility of the employee is going to be very important. Is it perception, or did it actually happen? Secondly, the employee or the lawyer representing him or her should write to the Human Resource Department and say, my client is experiencing this harassment. Then, as an alternative, or cumulatively, you can have the doctor, that personal doctor of that employee. By the way, that client has seen a doctor. And that doctor, have that doctor say that my patient is very ill. He or she is suffering from harassment in the workplace. If it continues along the lines that has been described to me, I foresee that my patient will be a long-term disability claimant. That can dissuade certain employers from continuing that kind of behavior, because long-term disability is a large damage claim to the employer. And if the employee is already too sick to work, so they're already at home, they've already obtained their leave from the doctor and are no longer at work, then what you do is you get the doctor to write stating that he or she attributes it to harassment, and you as a lawyer write and state that if this behavior continues, first of all, your client is sick because of the behavior. If it continues, please be advised, employer, that we will be pursuing a case for intentional infliction of mental distress. Now, in all of those instances, except where you want to claim constructive dismissal, that can all be done while the employee still has a job. Now, I just want to make reference to it, since it hasn't been referenced yet this morning, to the recent case of Clark versus Canada. Now, this one, as of last week's Canadian abridgment, was not cited. Although it was heard in April, I think it was reported in September. I'll give you the site. It's a very important case. So it's Clark versus Canada. It's 76 FTR, and it's 241. Now, Clark was an RCMP officer. She was also married to an RCMP officer. She was a woman, and I'm not sure what the statistics are, but there aren't so many women in the RCMP. And she claimed that she was being harassed. She was harassed, and excuse me for those of you who are well aware of the case, but I'm just briefly going to go over the facts. She was harassed in one instance by an RCMP officer saying about her husband, if you want a real man, then he propositioned himself. And then she was also told that, real women versus real men stay at home and look after kids, bring up kids and look after kids. She also was subjected to having plastic breasts attached to her locker with her badge number on it. Now, this is just, her superior, she also caught her superior, watching pornographic movies while he was working. There are some jobs like that. She indicated that she found this offensive, and he said, tough. Now, to her, this constituted harassment. Whether or not you feel it does, it was so continuous, and there are more examples of it, that it resulted in her being very ill. She didn't file a complaint for sexual harassment, which initially would have appeared to be the recourse to take. What she did is she filed she was so harassed she resigned. So what she did is she filed for wrongful dismissal, but she also filed for intentional infliction of mental distress, and she filed for negligence. Now, this is absolutely the first case to have found that the superior, senior, whoever her boss was, had an obligation when he was advised of the fact that she was being harassed. He had a duty to correct that behavior. And the court also held that there was intentional infliction of mental distress. So when I tell you of the practical ways of dealing with harassment in its early stages, you noted I said write to the Human Resources Department or write to his or her boss. What you have to do in that instance to be able to rely on Clark, by the way, that was federal court, it will find its way through the other courts, you have to put the company on notice, and that's what your letter does, and a doctor's letter puts the company on further notice. Now, I recognize I've probably got 5-10 minutes left, and I've got lots to go through. 10 minutes, thank you. Now, another one is changes to a contract of employment. Employees come and they say, I've been demoted, and they're taking away this bonus, or they're reducing my salary. What do you do? Well, there is the law as to constructive dismissal. What is a fundamental term? But again, because that law is really difficult to use, you have to have practical examples. And I have had a client who was given a change in the term of her employment. She entered into negotiations with her employee, and she didn't realize when the negotiations ended. And she was terminated for failure to accept the change term. She was a long service employee, and she thought this just wouldn't happen. And so you should and you must advise your, and by the way, now that's a suit, and that's the case I have to deal with at the moment. You must advise these employees, if you see them at this stage, at this issue, that they have to recognize that they're negotiating, and they have to know when the end is. So, to do that, a recommendation is for the employee to write and indicate that they appreciate that the employer is negotiating this very important term. So don't leave it up as if the employee has misinterpreted what is happening. Because if the employer wishes to say, I am not negotiating, this is it, then the employee will be better alerted to the fact that, hey, negotiations are soon coming to an end if they are not already at an end. Now, in addition, now there are many employers who are willing to negotiate. I mean, it's not as if employers just want to get rid of employees. Just because they want to change a term in a contract doesn't mean that they don't want to ensure that the employee is happy with the changes that are so critical to the employer. So another option is for the lawyer to intercede, and the lawyer to write on behalf of the employee and say that my client loves his job. I mean, you have to remove any acrimony at the very beginning, and is having difficulty negotiating with you, so I'm here to help. And then just remind the employer of the duty to bargain in good faith that has been mentioned already this morning. Now, another request often dealt with is obtaining a good reference, both oral and written. It's surprising how often I go to discoveries or ADRs, and I find out that my client hasn't asked for one because he or she was afraid of what was going to happen. It always works against that client or that employee. So it's terribly trite, but advise your clients to ask for it. Ask for it. It's so simple, and it's completely overlooked. And ask for it as early as possible. Now, the employer may come back and say no, and that's why the client is in your office. I mean, that's a practical result of the request. But there's no problem with the lawyer drafting one. Employees are very reluctant to draft their own reference letters because, of course, then if they go to a prospective employer and they say, oh, well, who drafted this? Well, I drafted it. It's really not such a strong letter. Nothing wrong with you drafting it, sending it, of course, vetting it with your client, and then sending it to the other side and advising the other side that this will not be held against you. This will not disallow you from claiming cause if you so choose to do. And this letter of reference will not be included in the statement of claim. Now, if that still isn't forthcoming, you can then write to the employer and advise of the consequences of failure to get that letter of reference, that being a longer notice period, that being, as Howard mentioned earlier, solicitor and client costs. And there have been punitive damages, Brown versus Findeman, and I've listed it in my works, where a court awarded, in 1980 albeit, $1,000 for failure to provide that letter of reference. Now, of course, if you're acting for the employer and you've got that request, if you so choose, you can give that letter of reference, but ensure that you do get the safeguards that should accompany that. That being that it will not prejudice your client's right to claim cause, and that it won't be referred to. Howard, how's my time? Okay. Another one, then this may be my last one. I have too many clients that come in thinking that theirs is the most interesting case for the front page of the Toronto Sun. And I must assist them because that will really tighten the screws to the employer. And of course, I start shaking. But I want to just mention that briefly because it's fraught with difficulties. But there are certain solutions that do exist. Now, first of all, I just want to mention the case. Perhaps you're familiar with it. I apologize if you are. Hill versus Church of Scientology. And there, the solicitor for the Church of Scientology, Mr. Manning, went before the cameras and stated something with respect to Hill, stating that injustice had been done. The Church of Scientology went further, commented quite negatively about Mr. Hill, who was a Crown attorney. The result was, by the way, they offered to, he sued, Mr. Hill sued for defamation. He put in an offer to settle, I believe it was $50,000, and that was 2 months before the trial, which took 6 years in coming. So a few months later, the trial is heard. Mr. Manning and the defendant had to pay costs of $300,000 for that brief moment on CBC. So it's completely fraught with danger. Be careful of it, despite how your clients do have all this fantastic material that would be of benefit to them. So if your client wants to do it, let him or her do it. Nothing wrong with them doing it if they want to. Advise them of the difficulties with it, however. Advise them of the potential defamation. Now, you may have a client who is still an employee and wants to whistleblow. Company is doing something illegal. Now, there is a case where it was found that this person whistleblowed, went above the company, I think it was to a government agency, to advise the agency as to what the company was doing. The government agency found that that wasn't actually the case, and the employee was terminated for cause. So ensure that despite the passion of your clients, that the facts are correct. Never, of course, extort, again, trite, never threaten, but you can do it. As Mr. Campion said, I mean, if you're going to do it, do it. Don't threaten, do it. And what we have done to deal with this situation, if you have a certain situation that you feel could prompt a settlement if it was exposed, what we've done is put it in a letter to the solicitor on the other side saying, we're claiming for sexual harassment against so-and-so. And then you say, and please be advised that if this isn't settled for this amount by this amount, we enclose here in the draft statement of claim that we will be issuing. Now recall, you can't threaten, so you issue it. And make sure that that statement of claim has as much of the information that you can legitimately get in there as possible. So, there are more suggestions. They're in my paper. So I hope that was helpful. Thank you,
Thank you very much, Constance. We're now going to have our mock pretrial, which has a composite fact situation that I hope you've had a chance to look at. I suspect not, but it will concretize very quickly. It relates to a lot of issues that we're constantly dealing with